Our next presenters are James Kennedy and Mike Vanahan on the Missouri Meso mess, Maness, Madness, and more.
Good afternoon. I'm Mike Vanahan, Jim Kennedy. They thought that we would be the best people to make you decide that you want to drink afterwards. So
as early as possible.
So we went ahead. Jim and I have done this presentation a couple of times. We've been involved a little bit in the mesothelioma, and we'll just kind of get to it and maybe talk a little bit. And I don't know, Jim, I'm okay with it. If you have questions while we go, I'm happy to answer them, or we're happy to answer them as we go, and we'll take it from there. So, Jim, you want to give us a little background?
Yeah, basically the game plan is we're to talk about the changes in the occupational disease law that became effective the 1st of this year. Secondly, there's a recent and pretty troubling Court of Appeals decision involving primarily medical treatment liability and expense liability for unauthorized, in cases where you did not authorize a treatment. Third, if time permits, we'll talk a little bit about employers' liability, because that's become an issue over the last year or so, and that was partially addressed in Senate Bill 1, again, that became effective the 1st of the year. But again, our primary focus is going to be on the occupational disease law and the new, well, non-existent Meso fund. So,
yeah, and the one thing that's kind of interesting is we probably don't have many answers. Because it's just the Meso funds just started, or at least the liability just started. I don't think the Meso funds ever started or may never start. But it's kind of an interesting insight into the legislative process, and so we'll try to even touch on the employer liability, because that's kind of got a fascinating aspect to it as well. Jim, first Senate Bill 1. Want to talk a little bit and the coverage on occupational disease?
Yeah, you know, for years, occupational disease in Missouri, you know, it's a separate theory of recovery. But, you know, if you contracted an occupational disease, you receive the same benefits as if you were injured through an accident. You know, the same medical treatment, the same lost time, and the same permanency benefits. And although liability was added, occupational diseases were added over the years, the benefits remain the same. And so all occupational diseases were the same until now, until Senate Bill 1. And what happened is that the legislature passed in Senate Bill 1 a statute that has treated 10 different occupational diseases differently than all other possible occupational diseases. And even so far as applying a different rate of compensation calculation to those particular diseases. And this is a radical departure from anything that's gone before over the long decades that we've had the workers' compensation law.
And just to highlight, I mean, what's kind of crazy about it is that as a result of the 2005 legislation, which was not very popular amongst many of the trial attorneys, what they basically tried to come back and say is that occupational disease coverage had been removed from the statute, which is a little hard to imagine when you had 287, 063, and 067 with the words occupational disease in it. Hard to imagine that it wasn't part of the statute, but that was a little bit of the argument and a little bit of the hook that the trial attorneys used for this legislation to go into place. Hey, we'll make sure we put the words occupational disease back in, and then that way we can get this enhanced benefit that we're going to talk about with respect to these little 9 and big 1.
Yeah, Section 287.067 creates a new category of occupational diseases to be known as occupational diseases due to toxic exposure. Now, there are 10 of those, and I'll read them off, and I'll mention what they are. One is mesothelioma, and as you may know, that's a cancer uniquely associated with exposure to asbestos. It affects primarily the lining of the lung, but it can also affect the lining of the heart and the stomach. The second is asbestosis. which is generally known, well known to be a disease caused by the inhalation of a certain size of asbestos fibers. Berylosis is due to exposure to beryllium. Coal miners' pneumoconiosis is black lung. Bronchiolitis obliterans is popcorn lung. And that's got a lot of press in recent years due to suits been filed against manufacturers of buttered flavored, particularly popcorn. Silicosis is caused by silica exposure. There's also a kind of tuberculosis associated with silica exposure. Manganism is exposure to manganese. The acute myelogenous leukemia is thought to be due to exposure to solvents such as benzene. And myelodysplastic syndrome is a blood disease, which is also thought to be due to chemical exposure. So this is a list of 10, of which one has been selected for special treatment. And nothing is special about these 10 diseases. And this is not an exhaustive list. So it's a little odd that these particular 10 were selected out of the many more diseases that could have been identified for the special treatment.
Well, I think between Jim and I, we probably have a lot of years of experience. But I don't know, we were kind of comparing notes about how many of these we've actually had. And I think I don't know that we've had between the two of us more than 5. So the debate that I've got going on is why all the trouble to do this if there's not many? And I don't know, I had a knee surgery and I was at home and I was sitting there on my couch and like every third commercial was, do you have mesothelioma? If you do, you can call, and then the number went up, you deserve to be treated well, or something like that. And I'm thinking, okay, why are all these commercials on? Why was this so important? And why don't we have any of those cases if they're here? And I don't know that I know the answer to that, but it seems something is going on. I mean, just a little inside baseball. I mean, a lot of the asbestos manufacturers, that avenue has been worked out. And Ron Hack, who is with our office, has done a lot of that litigation on the civil side. And I think that this is the last shot at how can we get some payout on the asbestos mesothelioma cases. Now, I have had asbestos cases, but you got to remember, this is going to go to permanent totals or death cases. But I've only had, I think, Jim, you said you had 1 or 2 mesothelioma cases, and I've got a couple being argued, but.
Yeah, I've only had 1 or 2. Now, we've all had some asbestosis cases, but they generally fall into certain categories of seriousness depending upon the degree of the disease. And it's a disease that can be fatal, but it's not generally any longer, at least, getting the kind of attention that Meso is getting. The odd thing about the diseases that aren't mentioned, like this, exposure to lead poisoning, mercury poisoning, exposure to toxic gases, to cadmium, the list is dozens could be, chemicals can cause even fatal consequences. Those are still compensable. If you can prove that you've gotten a disease due to a chemical exposure, a disease other than those 10 that have been selected, you still have a potentially compensable disease.
Well, and those 10 before they were selected were compensable,
right,
if you showed that they were related. So, why these 10, and then when we talk about the enhanced benefits, why enhance these benefits for these 10? But
the others are everything else except these 10 are just second-class citizens in the world of occupational disease. and we're not, intending to underestimate the seriousness of any of these diseases that they selected, and certainly not diseases such as popcorn lung or mesothelioma. But the point is, there's not a lot of logic behind the selection of those 10, other than whoever was behind it. Those who are behind it may have had.
Right.
Those are the ones that they've handled cases involving. But in any event, that's the reality, is that we have these 10 that have been selected for special treatment, and we've got to live with that fact.
Is this really the little 9?
Well,
Number 1?
Yes, that was, I thought that should read, and now how the little 9 and the big 1 are compensated.
So that's technically incorrect, so
And I'll take the blame.
you guys just take a break while we work out our slides. So mesothelioma is the big one, and the rest that Jim read are the little 9. And basically, what we're talking about is that there's an enhanced benefit with respect to those. So Jim?
Yeah. Well, first of all, you don't get the enhanced benefit by just contracting the disease. You have to become permanently and totally disabled as a result of the disease or die.
You got to be all in.
You got to be all in, right? You can't be you can't get 10% of the enhanced benefits because you only, 10% permanent partial disability. Now, I say that, but in reality, if you did get one of these diseases, I suppose that you could still handle it or pursue it like any other occupational disease if it didn't render you PTD or dead. But in any event, we're assuming that these diseases are in fact, have in that claimant's case rendered them unable to work completely or have caused them to decease. Now, in the event that you get one of the little 9 and not mesothelioma, the law now provides that you are entitled, or in the event of death, your dependents are entitled to, or your estate, 100 weeks of compensation at a rate equal to 200% of the applicable state average weekly wage, the SAAW.
Jim, you had figured out if you used roughly the most recent state average weekly wage, just to give you some number for the little 9?
Yeah, and in fact, the little 9, using the current, at least until the summer, state average weekly wage of $812.46, you multiply that by 200%, and by 200 you come up with $162,492. On the other hand, if you get meso, then the multiplier, the number of weeks increases to 212, and the multiplier to 300% of the average state wage. So that calculates to $516,724.56. No small change. And what drives these numbers is that, as you all know, in any other kind of a case, the rate of compensation drives the amount of compensation to be paid, and that's tagged up to the maximums, at least, to your average weekly wage. Well, this has no provision for average weekly wage. It says, so if you had a low-rate employee who had a less than maximum rate, they would nonetheless get that same full benefit as a worker who was making enough to generate the maximum PPD rate, in any other kind of a workers' compensation case, which is really odd.
Which creates a actuarial nightmare, I would think, and underwriter's nightmare with respect to what your potential exposure could be from a dollar standpoint, obviously.
Yeah. And at least if you do contract asbestosis, and then it does become, or you also incidentally receive or contract meso, the employer does get a credit for what they've paid for the asbestosis against the liability for the meso, because that could occur fairly easily. And the permanent total disability benefits and the death benefits, can't overlap. I mean, you don't have to pay, both. I mean, presumably, we think at least, if the PTD ended and you died, then one would convert. I mean, you would get some credit, but a lot of questions have not been answered because we don't know. It's a lump sum, but is it paid in a lump sum? There's a lot of questions that have not been answered, but they will be answered soon enough.
Just not today.
Not today. Maybe not this year. Maybe not this decade.
And I guess the thing that always is kind of crazy to me is that if you have a spouse that would pass away from any of these conditions. I don't know why the distinction between that and a spouse that passes away from the anvil falling and crushing them. It's not like it makes it less of a serious or less of a sad event. If both of them are compensable and one pays extra and the other one doesn't, I don't really understand, and there's really nothing that would say why the enhanced benefit in that scenario.
Yeah, there's a lot of mystery about how this whole how SB 1 got passed with these particular provisions at least got added. We'll probably never really know, but certainly when you look at mesothelioma, we know the kind of press and the kind of attention that's gotten. In fact, I Googled mesothelioma and I got 4,820,000 hits. Mesothelioma lawyer got 2,400,000 hits.
Not that we got some time on our hands.
You're right.
I don't want you,
Well,
you know.
asbestosis, only 1,000,004. And I said, poor manganism only got just less than 50,000, hits. So, I mean, how did
If you got some
manganism
time
make the
tonight,
list?
if we could try to see if we could catch magnetism up with some of the other ones, that would be appreciated.
But the point is that for some reason these got put on the list, and once they got put on the list, they're on the list. And some, like the manganism or the berylliosis, is not going to be very common. Asbestosis is going to be different, and we're going to see a share of meso cases.
Yeah, well, those popcorn cases caught a lot of attention in the state of Missouri, and I suspect that you could explain some of them by that. But again, it's really one of the few areas, and I don't know off the top of my head, I can think of it, one of the few areas where there's such a distinction between you get more benefits than someone else merely because you have this certain condition versus the other conditions, even if they leave you in exact the same spot, either death or permanent total disability benefits. And as Jim said, it's not to downplay the seriousness of any of these conditions. I just don't know that it's much consolation to someone if they lose a loved one from a death that is not these, that you say, well, it could have been worse, it could have been one of these. I mean, it's not like that's any worse. So, and that's really kind of the point of the next hypo.
And I was thinking this week, because of that tragic accident that happened at the circus, where the acrobats fell, and some of these people are going to be paralyzed for life, undoubtedly. Well, I mean, if that had happened in Missouri, and if you're a claimant's lawyer and one of those individuals became your client, I mean, how do you explain to that person who's 25 years old and who's a quadriplegic or a paraplegic, that if they had just been lucky enough to live to be 65 and have be diagnosed with mesothelioma, they would get this big payday, but they're going to get the standard workers' compensation benefits no matter how devastating their injury may be due to an accident, or even to of the other occupational diseases that aren't on that list. Not only that, but if you contract one of these toxic exposure diseases, the employer loses their right to subrogation. So you could have a civil suit against a third party who, a manufacturer or a distributor of the asbestos, and you could hit on that and you would still be able to get your full work comp benefits, which would not be the case in any other occupational disease situation or accident situation. But again, it's these 10 specially treated diseases.
Right.
That are the
It just makes the situation worse that you can't collect that money.
The Meso Fund.
Probably the only thing we can actually tell you, they sent a letter out to the self-insured saying, if you want, you're going to have coverage issues, obviously, because as of January of this year, these little 9 and big 1, which were always covered by work comp, now just have greater costs. And with respect to mesothelioma, they gave you the option of you can try to go out and get your own self-insured policy, your own policy through an insurance carrier. You can go with your self-insured group, or they said that they were going to create a Missouri Mesothelioma Risk Management Fund. The only thing that Jim and I have talked about it every time we've been is that that's not an option. No one would join, I don't think, the Missouri Mesothelioma Fund. And I think no one has joined, which is we should pat ourselves on the back for none of us ever joining, because what happened is you'd have to join, and then you have to elect a board, and then you'd have to figure out amongst that, well, what are your premiums, who's running it, how are we going to adjust it, how are we going to calculate all, so I mean, who would do that? What's really interesting about this is it went into effect January of this year. What happens with respect to premiums? We asked the division, you're insured by Travelers. What happens, you're insured by Travelers, and on January 2nd of this year, what happens if someone files one of the little 9 or the big 1? And their answer was, well, Travelers has got liability. And you say, well, yeah, but you know, if that policy comes due on April 1st, and they signed it last April 1st when this wasn't in effect, how does that work? Because they were never calculating a premium from a statute that hasn't been written, but now it's been written and put in place, and it's for your first 4 months of coverage with Travelers, or 3 months of coverage with Travelers, and you get hit with it. They've never calculated this particular exposure for the little 9 and the big 1, and they just seem to say that the insurance companies are going to have to deal with that when the premiums come due, because those are your options. And they put out a form. You could opt out of the Mesothelioma Fund. You can't opt out of the little 9. You could opt out of the big 1. But if you opt out of that, you're opening yourself up to civil liability. So your options are opting in with some self-insurance insurance plan or this mesothelioma plan, or opting out and having some civil liability.
Well, I'm not sure you can opt out of the little 9, but
you cannot.
You cannot. Yeah. Now, every employer, though, has to either accept or reject meso liability, and if you and you're assumed to accept it unless you reject it. But if you do reject it, you then lose your exclusivity protection, which means that you can then be sued in circuit court. So,
but the statute doesn't really deal with if you don't really affirmatively make the action. It was really unclear. They just put that in a letter. It's unclear what would happen if you didn't affirmatively make that election. I mean, you should, but that's just another issue.
As of the last time we checked, there were no members of the Meso Fund as of about 3 weeks ago. And I get this response if you call up and ask the division, they'll say, what Meso Fund? And the issue is that, first of all, who would join it? Secondly, why they would join it? Thirdly, what are they joining and why and how it's going to operate? But to get it off the ground, you have to have a board of directors. They have to be, 4 of which have got to be members, and the 5th is appointed by the governor. Well, with no members, you have no board of directors. With no board of directors, you have no organization to establish. The division doesn't need to establish it and staff it. So right now, it's going nowhere. So we have about 34 provisions in the law now that deal with the Meso Fund and no Meso Fund. So we'll see what happens, but it exists, and that law may be repealed at some point if there's no interest in it whatsoever. But it looks at this point like there's not going to be any interest in the fund. So which is no great shock, believe me.
That's what you just talked. So that's the good news on our first topic. We're kind of slowly getting into more bad news, and so. But if there's any questions, anybody have anything there? Yes. Okay. We got.
Okay. The question is, isn't it true that the not so subtle purpose of the enhanced OD benefits are to incorporate punitive damages to punish employers for what has been perceived, if true, that they're willfully ignoring safety procedures in response to all the bad press from the popcorn lung cases? Well, in fact, a lot of the thought behind the enhanced benefits is the fact that, well, industry ignored all of these years to protect employees from these dread chemicals, and now they should have to pay through the nose for it. Well, I mean, that cuts, that goes towards any other sort of a safety violation, or ignorance of any other kind of a safety or unsafe condition, or the other non-toxic, non-designated toxic exposure diseases. So I guess the answer is just that, some of the justification for it, and certainly from a standpoint of publicity, the popcorn lung cases and all of the publicity that Meso gets is partially, behind that.
But I think if you were really being honest about it and you said, hey, when they ignore safety, then you don't have a right to subrogation, the flip side would be if that's not the scenario, you would have a right to subrogation if a third party brought in something that produced one of these conditions and you didn't ignore safety, that you didn't know just like the employee didn't know. That would seem, if that was your true motive, was to address the employer who is not conscious of safety, that seems like it would be a wiser way to write it. But I think it's an attempt to be punitive and address one small issue, but it's a shotgun approach where it takes in all sorts of other issues that don't apply to the one issue, that are better than the one issue you're trying to address.
The next question is a good one. Are all cases subject to the new statute regardless of the date filed, diagnosis, or last exposure? I think maybe if we want to extend this from 4 to 5, and we can skip the cocktail party and the gift giving and the drawing, we can probably answer that question, but or attempt to. It's clearly a substantive change in the law, and so it can't be applied retroactively.
Right. Procedural can go back. Substantive can only go forward. So you can't get a ticket in the mail saying, hey, we changed that speed limit from 30 to 25, and last week you were speeding, so we're going to send you a ticket when you were going 30 and the speed limit was 30. So substantive, you got to go forward.
But what drives that determination is what was the date of the occupational disease, and the odd thing. Or scary thing really is that if you look at mesothelioma or asbestosis, but meso, let's focus on that, the latency period between the first exposure and the development of the disease to the point where it can be diagnosed varies between 15 and 50 years, and I think Ron would say maybe some people have argued 60 years. So, what law is in effect in that case? And so basically an occupational disease, it's when the disease is diagnosed. And if that's after the law, but I mean if it's before the law and the case is currently filed, that's yet to be determined.
Right. I mean it creates the whole issue that we run into, whether it be these or carpal tunnel cases of, diagnosis going to notice and liability going to disability. So we've had cases, I've tried carpal tunnel cases where it's been the same employer and different insurance carriers, and the question was, who's responsible? And it used to be that it was when the date they filed the claim, so everybody'd really hurry up and look at the date of the claim, and they'd say, oh, your coverage ended and theirs started, it was during their coverage. That's the answer. Now, when you look at the 2005 change, to me, I look at liability to disability. So boy, I'll tell you, the first one of these that comes down the pike is going to be interesting. The other thing I would say, I was trying to think of that the claim form has been changed. So the Missouri claim form, and I really worry about that because when I was asked about it, I said, I think if you're going to file one of these claims, little 9, big 1, it would be much better to have like a different color form so that we could at least see that there's a distinction, because the dollar amount is so great. But it's on the same form, and I know I was talking to Joan Holt, but like the first time we opened one of those, I was like, oh, wait a minute, is this one of those cases? But it's on the same form. You have to kind of look at it. It was a regular occupational disease case, but none of the boxes for this exposure was checked. So,
Yeah, the next question is the bar to the third-party recovery, that is the lack of any subrogation rights, retroactive, or does it apply to the new claims? The answer is it applies to any claim that falls under the new law, but not to any other claims that are not, that can't be filed and pursued under Senate Bill 1. So we'll it'll depend on what the date of the, what law is found to be applied in a given case by the
it's going to be
courts, so.
interesting to see a year, 2 years from now, if the topic is here and we say how many cases have been filed, because I couldn't even imagine what the over and under is on that. So, anything else?
One more question.
Oh, all right.
Is there an opportunity for negotiations on the lump sum or ability to purchase an annuity? Now, you know, the law as it's written speaks in terms of, you know, the Meso fund about awards of, you know, for for mesothelioma, which assumes a trial and an award. But, you know, outside the fund, it would apply, if you can prove that you have contracted the disease, then those are the benefits you have a right to receive. But there's no law that says you can't negotiate, you can't settle these. This is going to be like any other claim, and you can handle it however you're able to do. It's not an automatic benefits like, I would think not like an amputation. It's never going to be that clear cut. Try to think of a situation where you're going to admit a meso claim, or, you know, a lot of these other diseases, or you're generally going to dispute that based upon, you know, the last exposure rule, you know, a lot of other factors. And so, you know, you're not going to be just paying these dollars out automatically. They're going to be major cases, and you'll have the opportunity to resolve them, and that would certainly involve an annuity. Could involve an annuity. What we don't know, if you get an award against you, is that going to have to be paid? Or if you agree to pay it, can you agree to pay it not in a lump sum, but, you know, over time? But it is expressed, you know, as a lump sum amount. So,
Yeah, I think part of the goal here by the plaintiffs' bar was to get lump sum payments. So I suspect that there's going to be a lot of interest in trying to negotiate some of these. So I think that'll happen. Jim, we probably got to pick up the pace a little.
Yeah.
Because we get, why don't you want to?
yeah, the next bit of bad news that's good before before the cocktail party here, but it's a case of Maness versus the City of DeSoto, and although this was part of the update, this deserves a little special treatment, and it is a case that has a lot of issues in it, and a lot of issues were decided by the opinion of the Court of Appeals, Eastern District, but the issues of particular concern have to do with medical expense and, you know, having to pay or not pay. And in Maness, there was unauthorized back surgery, something over $100,000 in disputed medical expense, which the claimant was attempting to force the employer to pay. And the employee, the claimant, did prevail on the other issues. So the case reached the point where they had the ALJ and the Commission and ultimately the Court of Appeals had to decide, you know, what was the employer's liability for the medical. And the defense took the position that, number one, their liability should be limited under the Farmer Cummings Supreme Court case to only the amount for which the employee remains legally liable, plus the collateral source payments. You can't avoid those. Not the entire amount of the bills as charged by the providers. And the other issue is if we had to pay medical, if the employer did, who got the money? Well, the defense had an affidavit from the hospital where the balance of the bills were owed. And the affidavit from a billing person said, this account has been, in effect, resolved. You know, we've received the contractual payments, there's a group carrier, and the account has been resolved. They also had testimony from the employer's benefit rep who said, this is how our benefit program operates. our employees, if they, they're under this plan, it's a group health plan, and once the plan pays the plan amount, then the employee is safe. So that was pretty good evidence, you would think, to allow the employer to escape having to pay the entire 100 cents on the dollar, but only the amount, if any, for which the employee was still liable, which apparently was, in fact, zero. Well, that's not the way it worked out for the Court of Appeals. And the reason is that when the employee went in to prepare a hospital, and like we all do if we go to a hospital or a doctor's office, you have to sign these forms, a HIPAA form, and the form, I'll be 100% liable for all the bills of the hospital, the financial responsibility. That's pretty much automatic. Well, there were those forms still in the record, and the Court of Appeals, upon noting that evidence, said, well, that affidavit didn't say that those agreements were no longer in effect. The affidavit didn't say that that individual making the affidavit had the power to forgive that prior agreement. It's a technicality. Of course, those agreements no longer applied, but there was no proof of that. The other thing is that it didn't state that the write-offs and adjustments were for the benefit of the hospital. And that's not, we don't know what that means, but in any event, that's what the court ruled. They also rejected the testimony of the employer's representative on the grounds that she had not checked this employee's records, or his records, to say that the plan, in fact, had paid his benefits and he no longer had any liability. So all she said, this is how the plan works, but didn't say this is how the plan works in this case. So using those two excuses, the Court of Appeals said, no, you pay 100 cents on the dollar. And the second issue, on the second issue, and by the way, you've got to pay all of this $110,000 directly to the employee, not to the provider, not part here, but you've got to pay your total medical liability. There's nothing in the law that says that you can pay the hospital so that they, get the money back that, that the group plan had paid. It all went to the employee and his attorney. So that's not good news, and we now wonder what we can do to prove that that Supreme Court case of Farmer Cummings should save, us having to pay double in effect, or allow this double recovery. The hospital may argue, well, we may have to pay the group carrier back, there may be some reason you can argue that, well, there may be liability to the employee after the award that they need this money to protect themselves. But in fact, the reality is, as we all know, they're not going to have to pay the money back. That had been paid under the contractual obligation of the group carrier. So
I don't know. When I read the case, it seemed to me like a conclusion looking for a reason. And so they kind of took the scenario. I mean, before, the theory always was we just don't want to leave the claimant in a position where he has that potential exposure, which is why these steps were taken to show that that liability is not there. Now I just think it adds another layer to a case, especially a disputed case where there's a great deal of outstanding medical. The question becomes, boy, if our exposure on $500,000 that has been paid by group is potentially that $500,000 can go to the claimant and the claimant's attorney, it's going to creates just another level of concern. And as many of you know, a lot of what we're doing is you spend a lot of your time developing the facts. You take those facts and you put them to the law, and then after that, you start to find yourself being a risk manager and discussing what's the likelihood of success, what's our total exposure if we're unsuccessful, and this is just another, to me, just kind of another hammer that potentially you have to worry about.
Yeah, you wonder, though, if that affidavit had said, and any other agreement between the hospital and the patient is no longer in effect, and the write-offs were done for the hospital's purpose, would that have been good enough for the Court of Appeals? I question.
They make you think that, but
yeah,
I'm just saying.
I don't know in the next case it's going to be good enough. or if the employer's benefit rep had said, well, I called up, this might be hearsay, but I checked it in any event, and I got the documents, and they show that this employee's account is, is paid in full. Would that have been good enough? We don't know. Our fear is that, like Mike said, it's what they wanted the law to be, and it's going to be the law.
Right.
Whatever you put in evidence, and plaintiff's lawyers or claimant's lawyers are going to say, well, now I've got all this money out there. I was willing to just, ignore this because it's been paid. I'll try to get what the employee still owes, or if I'm getting lien letters, I'll try to get that money covered. But gee, I mean, there's now money out there that's just found money,
Right.
so it's going to make it all that more difficult to, to settle a case with a lot of unpaid,
Right.
unauthorized medical out there. So.
All right. I guess we'll go to the last topic. We're pretty short, but I think we can probably get this in. And that involves employer liability. This was an interesting call that we got about employer liability, where one of the trusts, the self-insured trust, got a call and a letter from the division saying, you can't offer employer liability in your work comp plan. And they said, why? And they said, well, your trust says you offer work comp and employer liability, but your trust was set up under 287, which is the work comp section, and therefore you can't offer employer liability. Well, the trust turns around to the division and says, well, wait a minute, you can't get separate employer liability insurance, and it's part of the work comp policy. And they say, well, we consider it two separate things, and we only have control over work comp. So we go to a meeting, we sit around a big room, they tell us it's not part of work comp. We say, well, you can't really separate it from work comp, even though it's a different liability, but it's part of it. You can't buy employer liability coverage separately. So what can we do? And they say, well, the only thing you could possibly do was put in the statute that you have the right to offer employer liability. So through a lot of the business organizations, they put into the statute that you can offer employer liability insurance since it's part of the work comp. After that passes, the division says, why did you put in that employer liability section? We said, well, you told us to put in the employer liability section so that we could offer it to our members, because a lot of the trusts said without this, we really can't, we can't function. And so, so then they decided that they would write regulations and for the employer liability. So they put out a group of their version of the regs, which we found not to be all that acceptable. And so we put out our version, which I assume we haven't gotten back yet, which I assume they don't think are very acceptable. And so that's kind of where we are. It was kind of funny, though, because when they put out theirs, they were like, we are in a hurry. This is an emergency. We must get this done right away. So we said, can you give us a week to create our own? Sure, but this is an emergency. So we created our own, and what's the time frame been? It's been maybe...
It's been, I think it was mid-February that they got our draft.
Right. So, and we're still waiting for them to come back. So I guess if nothing else, we averted the emergency. And, in fact, I talked to Commissioner Larson as he was leaving. I said, hey, you know, what's the story on this? Where's the emergency? And he said he actually had seen some copies of it. And so it's, you know, employer liability, I have to tell you, if you asked me 2 years ago what I knew about employer liability, I couldn't fill up an aspirin. And now, because of this, I actually had to go look at the employer liability. It was funny, I guess we were there with like 7 trusts, and they were trying to figure out bonding requirements for employer liability. And we said, well, you've got a pretty rich history. These trusts have been in business for 20 years, 30 years, you know, whatever. How many people here have had an employer liability claim? And I think we had one that paid just the cost of defense. And then maybe we had one other one out of the 8 groups. So it seemed to us it was an issue that probably never should have even been addressed. But as a result, it kind of created its own life.
Yeah. Which the division caused the issue in the first place. And now they don't like the solution, and now they don't know what to do. You know, and it kind of they called, you know, the hoist on your own petard. But to understand employer liability, I mean, that's the liability that can cover an injury on the job that doesn't fall under workers' compensation for some reason, but doesn't fall under general liability either. Now that's it's called coverage, well now coverage 2 was coverage B. And it's part of every workers' compensation policy automatically. Now this is not full coverage like for work comp. Coverage 2 usually has a common limit these days is $1 million. It used to be 100,000, then 250, now it's commonly $1 million. But that's not a lot of coverage if you happen to be sued after the 2005 amendments, but before the new law because of a toxic tort case. So that's one area where this could be, it is implicated. And the odd thing is that there's no market for coverage 2 outside of workers' compensation, Part A or Part 1. So if you're an employer, you know, and if you're not part of a trust, you know, and the only way you can have coverage, you can't have coverage A, either you have to be part of a trust that provides it as part of their work comp coverage or have a work comp policy. But in any event, it's partial protection where it's there. But the odd thing is everything worked for 27 years or 30 years, just no problem until that one letter last March. And now, you know, we've gone another year now and nothing's really changed a bit. So,
Well, that's our story. We thought we'd just bring you one bad story after another. I guess at this point, if I said like, "Hey, it's a cash bar," that would just like fill it out, you know. But that's not the case. I guess there's some prizes to be given away, and other than that, thanks a lot. And was there a question, Jim?
let's see. There was one more question. Do we place the health insurance on notice so they are paid if they assert a lien?
I guess in the Maness situation,
Yeah.
do you say, I'm not going to let them get away with that, I'm going to call the health insurance company and say, at least go ahead and file some kind of medical fee dispute?
Yeah, the problem is they can't come into the workers' compensation case because they don't have a lien in the, you know, they are not a party. All they can do is to use the medical fee dispute process, but that doesn't apply to unauthorized treatment, so they could go nowhere there. They can attempt to collect back against the claimant once the claimant collects that money, but you know that's between the claimant and the group carrier. Now, as to letting the group carrier what's going on, I mean, I guess you could do that. You know, I shouldn't say out of spite, but just to prevent, you know, a double recovery. So I guess the answer you could do that, but it's not going to get your money back. That's one thing. So I think that's the last question.
All right, thank you.